look, with the time we have left, I think I don't want to we're saving the best for last because, but in my estimation, we are. I love being a trial lawyer. I know the rest of us do too. Let's switch gears and talk about trial
Mm.
and the differences in trial. And as we do that, let's give a shout out to Keela. Week 1, episode 1, we're talking about the Marsha Gonzalez verdict, and you were a team member right there with us. It was a 3-person trial team, me, you, and John. And
Yep.
without your involvement in that case, you handled a ton of critical witnesses, including before and after. The client, that verdict of 2.5 million doesn't come home for that client. So hats off to you. Now that you're here, we can show our appreciation in person. But
Thanks.
having just come off your first multi-million dollar jury verdict as a civil litigator, maybe you could tell people what the differences are like in your experience now as someone who's tried a ton of criminal cases and is trying more and more civil cases every day.
There's a lot of differences. I'm going to try to narrow it down to what I find to be the biggest, which are the experts. Experts are so huge in civil, and that's, I learned that through the trials that you guys allowed me to be a part of, and especially this one, which is so heavy. And I'm not going to go into it. I'm sure, I know episode 1 you did, but, in criminal, I think criminal is very fact specific. Now you do have experts. You have fingerprint experts and DNA experts, and all these different experts that are necessary sometimes. But it's very fact specific. In civil, I feel like most of the trial, it really is battle of the experts. And I read that before I became a civil attorney, and now I understand it. And this last trial really brought it home. It really boiled down the importance of just knowing the science behind what you're doing. So I would say that's the biggest overall difference. But I mean, jury selection is different, right? In criminal, the jury selection, you definitely want to voir dire on your theory of defense. Is how you always, when there's a objection.
Don't pre-try your case,
Pre-try your
careful.
case,
Don't
Judge.
pre-try your case.
I am, I am just voir diring on my theory of defense, see if they're open to hearing my theory of defense. But outside of that, I focus so much on the Constitution. People take it for granted that everyone talks about your right to silence. And I think a lot of attorneys assume that the general public understands what the right to silence actually means. And most people don't, most lawyers don't understand what the right to silence really means. And so in in criminal, it's very much focused on that Constitution, right to silence, right to trial, right to, all the things that you want to make sure that the jury understands. And one question that I ask every jury member, no matter how big the panel is, you're chosen as a juror in this case. Some people get confused by that, by the way. They actually think they're chosen. They're like, congratulations, you've been chosen. As a
process of elimination.
Right. Right. So you've heard, the government has put on the entire case. You've heard nothing. This is the last time you hear from me. The defense does not ask a question. Mr. and Mrs. whomever, they don't get up. This is the last one. You're chosen. You go in the back of that jury room. What is your verdict? And people really say guilty, right? They say guilty, they'll say, well, why didn't you get up? Don't you have to say something? And I have to explain these things. And I think that those kinds of questions, I think, lead to not guilties, because if the jury understood what their job is, then you're, reasonable doubt. That's a very high standard. Juxtapose that with civil, right?
John, you've tried both cases.
John's,
What do you feel like the strategic differences or the challenges that are present in in civil, because it's a lower burden, but it's our burden, versus in criminal, it's reasonable doubt, a super high burden, but we don't have it. If we go into criminal trial, I could sit there and do a crossword puzzle all day and never put on a witness.
Mm-hmm.
I don't have a duty to do so. So maybe you could talk about that a little bit, having the burden and being what it is.
So I think that definitely having the burden is different. Mm-hmm. In the context, I actually like having the burden, because I think you get to talk about, like, I'm going to prove my case, hold me accountable, mm-hmm. like in jury selection. Like, you talk about educating the jurors. A lot of what we do is education, mm-hmm. right? Not just to our case, but into the law. Like, look, mm-hmm. you can have 49% doubt. You cannot be, I'm not really sure. We still win. Mm-hmm. If you're like, I'm not really sure, but I think so, like, mm-hmm. we still win. So, what I saw.
What does Keith Mindick say, your mentor? What does he say about reasonable doubt?
Well, reasonable doubt does not create an out. And it
Mentor
does.
by proxy, by the way. John's a voracious reader of Minnick's
Right.
material.
So, and it's
Right.
that's so like the way to look at the civil, because that's what they do. The defense tries to focus on things that don't matter to create doubt. Well, guess what? That's not reasonable doubt does not create an out. It's like you take things and put them in context, show why they don't matter, show why we're right. And I think when you're the defense lawyer, at least in my practices, Jordan had me come and this was my first trial ever in my life. And it was a criminal DUI trial where our client was driving the wrong way down State Road 84. Pulled over, stopped, refused field sobriety. And Jordan was like, come on in, you can try the case, just do opening statement, you're fine. I was like, I don't do criminal law. I've never been a criminal lawyer. I mean, I took criminal law and criminal procedure in law school. That was it, right?
Yeah.
So he says, you'll be fine. Just tell him what you're going to hear and then tell him what you're not going to hear. And that was literally my theme. And I got in, and at one point, and this is part of the fun you can have in trial, is I think I acted about what you're not going to hear or see and I acted like I was stumbling drunk out of a car and used the lectern as like a prop. I was like, you're not going to see any of that. You're going to see him on video, looks fine, talks fine, blah, blah, and he's going to tell you that he took his GPS, and if you go to State Road 84, you take a left instead of a right, which says do not take a left, you're going to end up on the wrong way, which is, he said, what happened. And so being able to take a case and poke holes and create doubt, of just saying like, look, like this doesn't make sense, and to his former partner, if it doesn't make sense, it's nonsense, and if it doesn't add up, it's made up, and I think
Shout out to the Miami PD's office.
Yeah, everybody in Miami knows what that's about.
and I think that works, and I've used that, in the civil context as well, because some of the things that they say, like to try to create doubt, that doesn't make any sense. And so when you can present that as like they have the burden, that's extremely high burden, someone's liberty's at stake, you take it seriously, and if like, look, if you're not sure, it's a not guilty,
Right.
and so you can't be not sure. Well, I mean, I guess you can have doubts, but they have to be reasonable, and everyone gives that. I don't know if there's like aliens or something they do in jury selection.
I don't want to hear another
Yeah,
prosecutor.
I know the rain.
Right.
No thanks.
Yeah.
But you know what I mean. So I think having done that and seeing, what you can do from the defense side, like you can have some fun. You can almost, and I saw. There was a trial, and I wanted to mention this earlier, and I know I'm going to backtrack when we talked about being fearful. Jordan asked me to try a case with him where the guy had like 4 life felonies he was facing that he said, I want to go to trial because I don't want to lose my right to vote. That's what he said. I don't want to be a convicted felon. That's important to me, and we're going, I'm not guilty. Jordan got the case off the wheel. All the lawyers were like, plea out, plea out, plea out, plea out, plea out. Jordan's like, you want to go to trial? Let's go to trial. Jordan's like, come try this case with me. I was like, 4 life felonies? Like, no thanks. I literally...
I don't know if you're sitting there at counsel table solo.
So I was fearful, but I came to trial. So I came to trial. I wasn't beyond the bar.
Yeah.
I was back here talking to Jordan. And he, we went in with like it was a setup job. Our client testified. Jordan's of like, look, you can, obviously there's differing views of thought here, but if you're going with actual innocence, like this was not you, not they didn't prove their case, like actual innocence, you have to testify. Jordan had him testify, and he was like, it was a raid of a house that wasn't his. They tried to say it was using the ID. Well, his ID had a different address. So when Jordan was cross-examining the cop, he blew up the ID. He was like, you said on this affidavit that the source of this information came from his ID. Here's the ID. What ID are you looking at? And it got to the point that a career, narcotics detective stopped court and was like, I just have to say something. This wasn't sworn. It's not an affidavit. Started getting like, and openly.
Got him.
Got him.
Right.
Right? And then he got...
That's when you just start walking back to counsel table, like, pay him no mind.
That's right? That's when you just drink your water.
And that was Mr.
Like,
Jordan flapping open his, his jacket. It was like, yeah, I appreciate that, but answer my question. Like, what ID were you looking at? And he didn't have an answer.
Well, listen, let me say, because I know we're running short on time, but I think this is an important point. In both criminal cases you've talked about, the first one you ever tried, that DUI, and then the one you were talking about that I handled with that drug trafficking case, both instances the client testified. That wasn't by accident. I feel like there's a little bit too much of lackadaisical thinking on the criminal defense bar. That's how I felt when I used to do it regularly in terms of, just never have them testify. Constitution protects us, it protects us. And I mean, yeah, that's true conceptually, but I think it ignores the reality of human decency, which is if you're asking me to walk you and acquit you, I'd like to hear from you. You know, that's a human tendency, and I don't care what a prospective juror tells you, but no, I won't hold it against you. I have found in my career that even if it is just a reasonable doubt case, to the extent that I can put a client on, I don't care if they have impeachable priors. That to me is like way overblown. With the proper prep, I think it goes a long way. And I have found that I've been able to obtain far more acquittals on very challenging cases merely because, in hindsight, the client testified and the jury found some degree of credibility. When they don't testify and all you do is leave it up to the mere speculation of the audience, so to speak, the jurors, I think you're in a lot more trouble when they go to deliberate because now they're just hypothesizing. I wonder what he or she would have said and things like that. Keila, how do you feel about, I mean, obviously in civil, your client's going to testify anyway. You just did the direct of Marcia in our case that got us 2.5 million. So you're familiar on that end. But as we kind of bring this thing down for landing this episode, maybe you can tell the jury a little bit about counseling clients on whether to testify or not in a criminal setting.
Yeah, I agree. It's case by case. I think what's cool is me and John tried our first case with you, so that's really funny because my first criminal trial was with Jordan as my co-counsel, and I think our client testified. It was the road rage case. Right. And so the beginning of my legal career, I was always open to it, and so now on a case by case basis, it's not something that I could just go, well, it's criminal, so he or she does not have to. It is the same evaluation as I would do with anything else. Is it necessary for you to testify? How would a jury see this, right? So I would say my clients have testified in about half of my criminal trials. Sometimes I just saw it as unnecessary. So just to kind of push back a little bit, I remember one case where it was an armed robbery. Just the evidence was poor, to put it lightly. And there was just no reason for my client to get on that stand. The only thing that he was going to get on that stand and say is, I was riding my bike on a beach one moment, and the next moment I was being pulled off by the police. He had no story to tell. He was innocent. It was just a regular day for him that he sat in jail for almost, a year waiting for this trial. But there was no evidence against him, and the government spent money to fly the witness from France to testify, where he couldn't even identify our client as the person who had robbed him, right? Just ridiculous fact.
And it kind of fits into, I once watched someone else try a murder case. It was a cold case that they brought, I think it was 15 years later. Mm-hmm. But it was one of my mentors, and it was in Miami. And I think strategically, the lawyer knew going in, the client wasn't going to testify for whatever the reasons were. Yeah. But knowing that, so yeah, you're right. Every case is different. He used something interesting in voir dire where he told the jury, look, I don't have a burden. So that means if we start playing this game, think of a sporting contest. By the time the state rests, the clock strikes 0. If I look up at that scoreboard and we're winning, I'm not going to ask for more time to play. Just walk my client and go home. And I thought that was a very creative way of foreshadowing to the jury in a case where the client's not going to testify. But look, this has been
Oh, sorry.
Go ahead, Gil.
Just one more thing. Sometimes you make the decision after the government put their case on. You've kind of prepped the client, but you do look at that scoreboard and you do kind of see, all right, you know what? I think the jury actually want to know this. Right. So you get to take your break. You talk to your client. Depends on the client for sure if they're going to be able to go up there. But I think the one other case we tried together, Jordan, that happened with his last name was Smith, but he got on there and they said, oh, you're on felony. You have a felony. He was like, I'm on probation, too. Right. That was right. That was one of those cases. We did not go into that trial saying that he's going to testify. We're like, you know what? This is ridiculous the way the government is painting this. And it's necessary for them to hear from our client. Our young black client who saw a black SUV in a high crime neighborhood, because that's the only reason it was a crime, it was resisting without violence. What do you think this young black man's going to do when he sees this tinted out, unmarked vehicle roll up behind him saying, yo, I don't think that's a cop. I think that is someone dangerous and I'm going to run. The jury needed to hear that side, but we didn't go in knowing they were going to hear it or need to hear it until the government rested with these, facts that were out there that really didn't represent what happened.
Well, I can say I've learned one thing unequivocally today, which is Keela needs to be a regular guest spot on this, because she's a wealth of information and experience, and her perspectives are welcome. So Keela, thank you for joining us today. We're definitely going to have you back. And for everybody out there, thank you for spending the time. And don't forget, if you're watching us on YouTube, smash that like button, subscribe, or if you're on Spotify, wherever you listen, feel free to rate us and share us. We appreciate it. John, any parting words for the audience?
No, I just, thanks again for tuning in. But, I'm really, I'm amazed at how far you've come since, and in the short amount of time. And I'm excited to watch you grow and develop as an advocate, as a trial lawyer. And I'm fortunate that you can be here for our clients. So thanks for coming.
Thank you.
You're welcome.
Thanks, guys.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter, or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.